Hello everyone. If you are watching this video because you are a director of a company and worried being arrested or held liable under the Prevention of Money Laundering Act just for being a director, then this video is for you. I understand how scary and confusing this situation can be. But don't worry, I am here to explain your rights, your risks, and most importantly, what you can do to protect yourself. This is Dr. Arjun Chowdhury, advocate, and I welcome you all to this new episode of White Collar Crime Legal Series. First, understand this. A company is a separate legal entity. It can be prosecuted for the crime it commits. But as a director, you are the person responsible for running the company. So the law sometimes holds directors personally liable, but only if certain conditions are met. Under the PMLA, the Enforcement Directorate can prosecute directors if they believe you had knowledge of money laundering or if you were in charge of the company's affairs when the offense happened. But simply being a director is not a crime. So when can a director be arrested or held liable? If you were actively involved in the crime, or if you authorized or consented to the illegal activity, or if you were negligent and failed to prevent the offense despite being in a position to do so. The Companies Act also says that anyone in charge of the company's business at the time of the offense can be held responsible unless they prove that they had no knowledge and they exercised due diligence. Here is what you should do if you are in that situation. First, document your non-involvement clearly. Keep records proving you did not know about or participate in any illegal acts. Show evidence that you were not managing or directing the specific transactions or activities under investigation. Another big issue is proving that you exercised due diligence. This means you must be able to show that you took reasonable steps to prevent illegal activities in the company. For instance, setting up strong compliance and anti-money laundering policies, regularly reviewing companies' accounts and suspicious transactions, conducting internal audits and getting third-party verifications, reporting suspicious activity internally or to the authorities as required by law. If you have all this documented, it strengthens your defense. If the ED calls you for questioning or starts investigating, here is my advice. Immediately get expert legal help. Don't try to face this alone. Do not panic or confess anything without your lawyer's advice. Cooperate, but remember, you have the right to remain silent and not self-incriminate. Collect and preserve all documents showing your role and compliance efforts. Be ready to legally challenge any wrongful accusations that you had knowledge or were responsible. To avoid getting into trouble in the first place, always stay actively involved in the company's affairs. Implement and monitor robust compliance mechanisms. Train your employees on laws like the PMLA and your company's policies. Keep detailed minutes of board meetings and decisions. Seek regular legal advice on your duties and risks. So to sum up, being a director does not mean automatic guilt under the PMLA. The law requires proof of your involvement or knowledge. If you act responsibly, keep proper records, and get timely legal support, you can protect yourself. If you want more detailed help or case-specific advice, feel free to reach out to the experts who understand this complex intersection of corporate law and criminal law. Thank you for watching. Stay informed, stay prepared, and stay safe. This is Dr. Arjun Chowdhury signing off. Jai Hind.